Thanks everyone for joining us. This Financial Poise webinar, the M&A process, is part of the private company M&A Bootcamp for 2025 and is sponsored by Max Asset. Slide 6 of the PowerPoint deck summarizes this episode, and slides 7 and 8 summarize the series. Speaking of the slides, we're not going to step through the slides in any kind of order. You're not going to have to listen to us regurgitating the slides. The slides are just an aid for you to follow along if you're so inclined. This webinar, like all Financial Poise webinars, is an informal conversation on the topic. You can keep the PowerPoint handy if you so choose. If you're old school, at least like I am, you could print it out and take notes on it. So feel free to use the PowerPoint as you wish. Our panelists we're joined today by Bob Decker. Bob is a managing director at the Peakstone Group, which is located in Chicago, where he's responsible for transaction origination and execution with a primary focus on the food and beverage industry. He's a career capital markets professional and operating executive with extensive experience working with companies ranging from emerging growth to large publicly traded companies. He specializes in developing and implementing creative capital formation strategies and solutions and advising clients on alternative approaches for maximizing shareholder value in connection with M&A activities. We're also joined by Alan Grafman. This is actually my first webinar with Alan, so welcome to the club, Alan.
Thank you.
Alan serves as CEO of All Media Ventures, where he focuses on business development, capital sourcing, and board of directors service with and for private equity, venture capital, and media companies. He has over 30 years of experience raising capital and leading M&A transactions for media, licensing, and content technology companies, and closing numerous transactions in all sectors of business driven by ownership and monetization of intellectual property. Lastly, Alan is a registered investment banker. We've got Phil Buffington rounding out our crew today. Phil is a partner at Black & Bingham LLP, a corporate law firm, which is located in the southeastern United States and Washington, D.C., where he represents financial institutions in a wide array of transactional and regulatory matters. I am your moderator. I am Robert London, and I am a partner at Jasmine Schlesinger Narendran, which is a full-service law firm in Garden City, New York, which is a stone's throw outside of Manhattan, New York City. My practice as a transactional attorney spans from M&A, obviously, to venture capital, startups, executive compensation matters. Basically, anything that's tough to negotiate and fund a draft and vice versa is what I do and still enjoy in so doing, as we say in the legal business. We appreciate that you're not spending your time and money to hear infomercials, as riveting as they could be. Our full bios are at the back of the PowerPoint. This webinar is a production of Financial Poise. More about Financial Poise is on slide 52. If you're attending the live premiere of this webinar, you can submit questions using the web portal. If you're watching this on demand or you have any questions after the webinar, you can send an email to info@financialpoise.com. Remember, the PowerPoint conversation we're about to have are meant for general educational purposes and do not substitute for or serve as a substitute for your need to consult with an attorney, an accountant, or other appropriate professional. In other words, if you hear something today and you try to apply to some deal that you're working on, but it doesn't work, and you didn't take extra steps to ensure your success, don't come looking up our bios at the back and to track us down. That's on you. Once again, thanks to Max Asset. All right, away we go. Let's get this party started. I'm going to start by tapping on Alan. Alan, I'm a business owner. I just started to think about selling my business. What starts my process? Or if I didn't start the sale process, what prompted me to consider a sale transaction? What would be my next early stage steps be after you answer the first part of the question? And let's talk a little bit about very preliminary due diligence as well. I know I just threw a whole stew at you. Pick whether you want to start with a piece of meat or a vegetable or fish or whatever part, if it's a bouillabaisse,
So I'm hoping to pass this first outing with Rob and get invited back one day. And it's great for the audience because I am neither an attorney nor an accountant, although I've played both. So I can summarize an answer to this first discussion with a very simple proverb. Don't wait till you're thirsty to drill your well. So by example, If you are selling a residence, you don't wait till the broker is bringing in qualified buyers to look around and figure what needs to be done to make your house appear the most sellable. You take care of that before you start the process, or else you're wasting a lot of people's time and you're going to have an unhappy outcome. So, what does that mean in practicality? So, it means that open issues that would be a problem or a concern or just a topic of conversation, you should try to remove from the equation. I phrase it sometimes as let's get from A to Z. Anything that is a detour is not good for a sale process. So, what could those be? Well, you can probably figure open lawsuits. Those are showstoppers often. Open lawsuits that are not resolved. They don't prohibit a closing, but they can obstruct one. Employee issues that can be lawsuits or open contracts or open vacancies in key positions. That can also be a conversation. And you want to keep the conversation focused on your business and not on these types of issues. Um, Vendor relations or sales relations. If you have an enormous amount of your business with a buyer or a company where there has been tumult, or there has been even worse, perhaps a financial distress, that is something that you should take into consideration. It may affect your timing. You may want to wait till it gets squared away. You may want to find alternatives, but you want to be thinking from a perspective of a buyer. And then there's always unexpected issues. And I'm going to give two from my own experience. I recently got a call from a company owner that I've been in touch with. We've actually known each other 20 years. This person has serious health issues, unexpected serious health issues, and he wants to wrap things up for his estate. And it would have been great if we had started this conversation 6 months earlier. Another was a client that we had a successful transaction, but there was an open lawsuit. So again, drill your well before you're thirsty, try to remove topics of concern, and start the process earlier than you think you might. You don't have to act on it, but it's good to start it early. Rob, how'd I do?
Those are very great and influential and important macro issues. I would add, being the fine tuning part to this question, is think about some of the mundane things. What kind of shape are your books and records? If you've been a corporation or for forever long, do you have minute books? Is the company in good standing? Like certain things, once preliminary due diligence gets started, if they're really a complete mess, will be very off-putting. And financial buyers, especially who have a longer and harder road to get through just to figure out whether the company's worth buying, tend to be put off by really messy situations. Anyone else want to chime in? All right, let's move this puppy along. Phil, let's say I'm a mid-cap private business owner and I get an unsolicited visit from a suitor. What do I do? I mean, I've never thought about selling my business. What do I wish I had done in preparation for today? And I kind of hinted, I sort of greased the wheel here for you by asking or answering Alan's follow-on.
Well, and Rob, one of the things I want to follow up what Alan had said, in my opinion, if they've just shown up and you haven't done anything, then you're behind the eight ball right away. Because I always tell my boards, prior planning is essential to success in anything you're doing. And considering your strategic plan, whether that's being a buyer, a seller, or neither, remaining independent is really important. But if somebody shows up and you've done none of that, the first thing I would say is gather as much information as possible about the potential buyer without disclosing any confidential information about yourself. Because if they show up with an LOI or they just show up talking about wanting to buy you, at that point in time, if you've done no planning, you've got to make some key decisions. You've got to determine whether or not you're going to engage an investment advisor, which I'd suggest you do. you're going to need to decide whether or not you're going to engage an attorney, which I would suggest that you do. But after you've done that, you've got to consider all the options. Is the buyer serious? Do we have an NDA in place to make sure that no information is provided that shouldn't be provided before it's in place? And then you've got to assess and evaluate the offer. I mean, if the LOI or the option is to have an exclusivity period for a period of time, is that what you want to do? Are there other interested parties? And what's the value of the company? If they just show up, chances are, if you've done no planning, you're not going to have a real idea about what the value of the company is.
So let's talk a little bit about exclusivity for
Okay.
purposes of an LOI. You're in a negotiation of an LOI. Everyone can chime in, perhaps not all at the same time, but how long of a period do you give exclusivity for? Do you give the buyer a right to extend if they want to, or does there have to be something going on? Is a deposit asked for, sometimes given for exclusivity? You know, what goes on as far as exclusivity goes?
I'll
It's
start with,
usually, I'm
go
sorry,
ahead.
Phil. I was just
No,
going to
you
say
got,
it's usually 60 or 90 days at the very least, and just giving time to get, the purchase agreement done. Go ahead, Phil. If you want to.
yeah, and that's what I was going to say, 60 to 90 days. And really that gives you a chance to start due diligence, get the purchase agreement done. And there could be an extension in there. And I will tell you, in some of the regulated industries that I deal with, in particular financial institutions, even when we get to the purchase agreement, I'll have a provision that allows the board, even after the agreement is signed and publicized, to be able to have a breakup fee. If somebody else comes along and makes a better offer, then I've got a termination fee that I've got to pay the buyer. And that's just to protect the board from a fiduciary standpoint. And I see that a lot with financial institutions. But again, like Bob said, I think, I've seen 120 days, but that's going to be if you've got a lot of due diligence and the complexity of the transaction.
Usually,
I'd
as
like
long
to,
as there's a good faith effort to keep both parties are working towards a closing, there's usually an expectation that there will be an extension for this. And when you're doing, particularly with an asset purchase agreement, not to get into forms of agreements, but you have to go out and get consent from all of the parties who are involved in your deal and have contracts. So you need assignments of those things, and that could take a while.
I'm going to advocate for 60 days, because ostensibly, unless it's a very, very complicated or very large transaction in the middle market, lower middle market, you ideally there have been other parties that are prospective interested, and you don't want them to go totally cold. 60 days is enough time for a buyer and a seller to know if things are on track. And of course, it can be extended, and perhaps for a fee payment. But 60 days allows one to make significant progress on smaller deals to actually close. And it allows that if things go sideways, which they do more often than anyone here would like, it allows you to rejuvenate interest from other prospective interested parties.
Fair enough. All points well taken. The one thing that I might point out, at least as far as the financial institutions go, I mean, for me, most of the time I'm in mid-market private M&A, or I'm on the sell side where I have a generational business where there's no new generation who wants to come up and take it. At that point in time, I don't need shareholder or board approval really to extend. It's pretty close knit. There's not a lot of hoops to jump through. The question is, as we said, is progress being made, or is really the buyer just looking for some sort of optionality? Then perhaps you ask for some sort of extension fee. But getting extension fees are pretty rare, because it's rare that you've been at it for 60 days and one side thinks clearly that progress is being made and the other side thinks no progress is being made. So that's kind of what I see.
Like quality per asset too. And Alan, I'm sure you're only dealing with A+ assets, where you can demand 60 days. And
Bob,
if you
you're going to be my agent. You're
there
going to
you
be my
go.
agent.
If you have a deal with a little bit more hair on it, the seller is going to be a lot more accommodating on that, I think. So
Well, and don't y'all agree, if you've already gone into this and you've got somebody that's come in and you've shopped the business and you've narrowed it down to a person, then it could be a shorter period of time. Because you know who's out there. But like Alan said, if I've shopped it and I picked one, I don't want to string that out because the others may leave me.
All right, I'm going to stick with Bob, and let's keep from the sell side for a while. We talked a little bit about due diligence. Like, what sort of information am I as a business owner being asked to provide? What kind of protection do I need? I heard reference of an NDA. Like, does someone sign an NDA? Am I letting him under and into the TP completely, or am I still holding certain things back? Just because I signed an NDA, what kind of information am I giving early? And, what's, from a strategic point of view, should a seller be considering?
obviously you want to get an NDA in place. And typically when we're marketing a business, an NDA goes out coincident with a teaser to everybody. So before they see anything beyond a high level, anonymized teaser, they have to sign an NDA. So at the outset, initially, typically what a buyer is going to be looking for is detailed financial information, both historical and projected. They want to look at any descriptions of the business, strategic plans they might have, other requests that are probably less, proprietary to the seller are, descriptions of their property, plant, and equipment. How many employees? Are there significant contingencies? What sort of intellectual property they have? Those sorts of things. Now, there are several items that we typically advise, and oftentimes they don't need to be advised about this, but there are items that we suggest a client hold back until a later stage. And those typically involve client information, specifically who their clients are, what their rankings are within that. We might also be a little bit sensitive about key suppliers. Furthermore, I would say, some of the details regarding cost of goods when you get into that. Again, some of that may be dictated by whether it's a financial buyer, a private equity firm who doesn't already have a stake in that versus a strategic buyer who, what you just want to make sure is that, you're making sure that the buyer is not just coming in to kick the tires and get a free look-see at the business. So those are things that we typically would hold back.
If I can amplify what Bob just said, usually when I go into the market as an investment banker for a client, usually on an exclusive basis, we do a teaser, which was just described. It goes wide. The company's usually cloaked. Not always. Sometimes the seller wants people to know, but let's say it's cloaked. It's a teaser. You get inbound. At that point, for them to have access to the type of data that's just been discussed, we will require an NDA. They get access to a data room, which we'll talk about later, which has most, but not all of the information, because that is available to many parties. Once one party has been selected based on their preliminary review, and one party has signed, let's say, an indication of interest and given, I'll say, additional evidence of capability to close. At that point, you have it's a marriage of sorts, it's an engagement of sorts. And at that point, you have to share everything.
I'll chime in with a couple of war stories. I've done negotiated deals up to, concurrent sign and close with a purchase agreement where the disclosure schedules are really left up to the very last minute, especially where the sell side does not want to reveal its top customers and suppliers. And that has been somewhat common. And I've seen it sometimes where at the end of the day, it's unsatisfactory to the buyer. It's a surprise where they see the last, the top 10 customers for the past, 3 years. The other side is early out in my career. I remember being as a young associate, I think it was sent to, Memphis for a week of due diligence. It was public M&A, a little bit different from off topic here, but it was, an old style data room, which means it was in a hotel room with boxes and boxes of boxes, where it's my responsibility for a week to basically digest and summarize everything. Each and every contract, each a bit of information, other than the name of the target company and the date, was completely redacted. So there was no useful information. There was nothing for the summer, yet I had to plow through all of these things like, contract with XYZ party, term, blank years, percentage royalty, blank percent. So that's the extreme. So it is sort of a balancing act, and it's a comfort level with the parties. At what point in time do you share the secret sauce? I mean, if you're Coke and you're going to be bought by Pepsi, are you giving them the Coke recipe on day one? No, you're going to give it to them very much closer to closing, I would think. All right, so that's an old style data room story there. What's a new style data room, Phil? Who's responsible for it? Who pays for it?
Well,
Again, what kind of concerns would a seller have in populating it?
I think Alan had a great lead into that. And I think we've got to start with what kind of data room are we starting with? If we're reaching out to potential multiple purchasers, we may have, using the term y'all used, a teaser room that we could give people access to in the data room. And that's really to determine if there's an indication of interest in buying the company. It's not going to be detailed, and you go through that process, and then you pick the person that you may enter into an LOI with. And really from there, you close the data room to all other parties and use that same data room to update it for the person you're negotiating the sale with. And this is leading into the acquisition agreement. At that point in time, anybody can establish it. If you've got an investment banker involved, they're usually the person that I have experience with establishing it, but the buyer or seller could establish it too, depending on what was going on. But again, if the investment banker or consultant establishes the room, that's when you start putting all the information in. That's when you've got an LOI in place. That's when you really may expand. Your NDA ought to cover everything going into this, whether or not you're just looking for an indication of interest or you've entered into an agreement with somebody to start real due diligence. So the NDA shouldn't have to be amended. It ought to cover everything. But when you start getting into that, some of the stuff that the seller has to do is, and this is where and Alan, it may have been you, when you said everything goes in there. I wouldn't necessarily say that everything goes into the data room in due diligence. I think there could be a slow walk there. There's certainly some information that you need to have to make sure that they understand. But confidentiality is one of the biggest things for sellers. Controlling access to that data room is certainly an issue, and making sure that whoever has access is covered by that NDA. And most NDAs provide for that. So that's not that big of an issue. I've run into issues where my seller thought they had everything in the data room. We get close to closing and they start raising questions, and they realize that they hadn't put everything in there that they need to put in there, some third-party vendor contracts. And so we have to update that. But it's a continuing effort if you've got an ongoing business. And that's the biggest thing that I think you have to make sure is that the due diligence checklist that you get from the buyer, that you've answered the questions, that you've provided the information that they requested. And I'll get to, and when I say maybe you don't give them everything, there have been instances where I've been in a transaction where there was substantial litigation, and we talked about that a little bit earlier, and maybe you don't get into the attorney-client privilege part of that information, and you give them more of a guarded response to their answers on the litigation, but you let their lawyers make the determination on the success or failure of a piece of litigation.
So Bill covered a lot. Let me try to amplify. So first, let me start. A data room allows you to keep track of who is coming in and who is not bothering to put time against it. So that's one of the benefits. Secondly, when I said put everything in, that's not giving access to everybody. Third, I generally, again, as an investment banker, I give the list early on in a process because otherwise you're going to have such a delay. If my client is waiting for the buyer's list of due diligence, it's then like, well, wait a second. We're gonna gather that material and we'll have it in 1 week, 1 month, 2 months. I always give our client, look, here's a list. It may not all apply, but you need to be thinking about it and working in the background. As it relates to the actual data room, Phil actually pointed out, sometimes the client will put it up on a Dropbox and manage it themselves, which we don't recommend that, but some clients want to do that. We have a secure vendor and we charge a nominal fee to maintain that for our client. And we want to see the documents. We'd like to see them before they go in there because we don't want the client thinking that, yeah, we're done. And we look at it, it's like, no, this is not done. And I'm sending it back with some questions, some notes. So maintaining the data room for lower middle market types of companies is it's important for all companies, but it requires perhaps more hand-holding, more supervision than for large companies or large public companies that have done this before.
Well, and Alan, you make a
Yeah.
great point, because if it's the person's first transaction, there is going to be more hand-holding. What you know they need to put in there, they may not realize is really a response to due diligence request.
I'd add, virtual data rooms are very sophisticated these days. And typically you might have levels of confidentiality. And we have even had where a buyer wants to get into that second level of confidentiality. Well, as soon as they click on that, we'll have a confidentiality agreement pop up and say, if you want to look at this, you need to agree to the terms of this, more enhanced confidentiality agreement than what we've already signed. So everything goes into the data room. It's just a question of when you give access to that. So
I'll add two sell side tidbits and then one buy side tidbit, which is a lot of people in the data room process and in the NDA process on the sell side forget to include a no solicit. Like, if I'm going to give you a list of my officers and my key employees and what they make, it's hands off. The other thing is, depending upon the buyer, whether it's synergistic or financial buyer, or they're being advised by a financial advisor, I want to limit access to my people, and I want to make sure that there's a named conduit in the NDA as to who I'm able to look to, who's going to be the only person who's asking for questions, so I can avoid sort of spontaneous leakage of information. I want to be able to control the process. From the buy side, and I've been known to be somewhat aggressive negotiator on the buy side, if I have at least a semi sophisticated data room like this, I'm going to make a representation of warranty put on the seller that they're going to rep that the data room is true, correct, and complete in all material respects, and I can memorialize that by a thumb drive. I could do something, but like, this is it. This is what we're relying on. It's really a very broad 10b5 rep and warranty, but it's memorialized by that thumb drive. I've been pretty successful getting that, and that's partly because it's not really unreasonable, even though it's somewhat aggressive, and it's pretty easy to memorialize because this is what it looked like at this date. So I don't know if any of you have run across that request or have actually made it like I've had to. I'm taking from the silence that everyone thinks it's a great idea. They're putting it into their notes on their printed.
No, representing a seller, I don't think we'd agree to that, by the way.
Oh, well, come down for, I think, episode 4 or 5 where we have mock negotiations.
No, the reason we don't is that in the actual purchase agreement, whether it's assets or whatever, all of that is dealt with sufficiently. So whether along the way there was something that was subsequently corrected, advising a seller, we would advise them not to accept that.
And from the buy side, it might make a buyer uneasy based on the nonverbal communication on the Zoom I get when I ask that question, to see how uncomfortable the sell side is with giving that. But that's let's move it along. That's a fun one. I'm going to flip the coin now. I'm going to stick with you, Alan. You're going to put on your strategic buyer hat, and you're looking for a good synergistic acquisition. Are any of the steps different that we talked about? Just putting more of a buyer side, synergy hat on. What are you looking for? What steps do you take?
So again, as a banker representing a buyer, the most important thing in qualifying a potential client relationship with a buyer is, do they know what they want? Because otherwise, any road will take you somewhere. So we have done some of these, and some have been. It's really hard, by the way. Let me preface. It's really hard because so first, you want them to do a lot of internal work. And large companies, that's not a big ask. For mid-sized companies who haven't done it before, if it's the first time, it's not, let's say they've done the work, or let's say there's a single, sometimes it's worse, there's a single decision maker. Well, you may start out where they've done the work. They've said, we want to see something that looks like X, Y, Z, and you put a lot of time, energy, and effort. And it turns out that XYZ is not really what they want. Well, that's okay. That's okay. Clients are entitled to do that. But the point is that you want to try to make certain that as much clarity is possible before I, as a banker, go out and bring them 10 or 20 prospective conversations. Because we've had instances, Rob, where not me, but a team member spent a year, was compensated, but spent a year and it was fruitless. And even worse than fruitless, the client wasn't happy. So buy side situations are in some ways more challenging because rarely is there the commitment and urgency that a motivated seller brings.
Said Alan, totally endorse what you said. You have to drill deeply down with that buyer to understand what they want, or both sides get frustrated. The advisor saying, geez, I showed you 20 deals, you didn't want any of them. And the buyer saying, geez, my advisor showed me all these crap deals that you didn't want anything to do with. So
Ouch.
it's tough. So
I'm actually going to stick with Alan now because there's a lot of talk, at least. I've had many deals slow down because of a quality of earnings analysis. And for the folks sitting at home watching on their computers right now, Alan, tell us a little bit about what's involved and what is a quality of earnings analysis. When does it happen? And, should a seller always be prepared to engage in that or cooperate with that? And what kind of access is needed? Let's talk about quality of earnings and talk to me as if I was going to say 4 or 7. Let's make it 24.
I'll make it real short, Rob.
Mm-hmm.
So quality of earnings is close to, I'm going to say it's a requirement for any significant deal that we work on. It's a requirement to be prepared. I've worked on smaller deals where there was not a quality of earnings, and smaller, I mean low 7 figures. But for most significant deals, the quality of earnings is a separate report prepared by the buyer by an independent entity that looks at the books of the seller in every possible way, and I'm going to go through 6, to see, is this business, is their reported financial statements sustainable? Not are they accurate, but is this sustainable? Is what I am buying going to look pretty much the same, everything else external being the same? Is it going to be a sustainable business that I am buying? Or are there factors that properly accounted for make these earnings not sustainable? So what is the quality? And you can think about quality a couple ways. First, let me go through a bunch of ways. So first, let's talk about revenue. How much of that revenue is going to come year after year from a consistent base of buyers of product? Or is there a huge buyer that is having problems? Or was there a one-time sale on accounting issues? What is the nature of their accounting issues for revenue? Accounting issues would be a second. A third would be concentration. I touched on that a little bit. A fourth would be one-time events that took place. Maybe they were wonderful, and maybe that increased the value of the company at that moment, but are not sustainable. How much of reported earnings gets converted into cash? So a quality of earnings is done by an outside firm for the buyer that looks at all aspects of reported financial statements. And that's by the way, on occasion, they uncover problems. And by problems, I mean not problems of interpretation, but I'm gonna call it fraud. That happens also. So for mid-sized deals, you need to be ready for that and expect that. And I don't know buyers that will do it without a quality of earnings report.
Alan, that was a good summation. As a sell-side advisor, we won't even take a deal to market, whether it's a sell-side client or even a financing client these days, without a Q of E. It's almost table stakes now for somebody going out to the market. Now, the buyer may also do their own independent Q of E or have the sell-side Q of E reviewed. But, for us, we want to know, and we want them to know before they go to the market, where are their issues? And also, too, as you talked about the adjustments, the one-time adjustment, what you see today almost inevitably is adjusted EBITDA for taking away owner's comp, excess perks that are in there or one-time expenses. And those are the things that we always try to make sure are covered in that. So,
which is an interesting topic because on the one hand, you have a family business and there are 4 children on the payroll and there are 8 cars on the expenses, that will not continue under a new buyer on the one hand. On the other hand, sometimes closely held family businesses are like, what do you mean we got to let someone know that I've been paying my cousin's tuition out of the company, so they have to get a little bit of a heads up as to what it is, what the analysis is going to be. And for that type of situation, it can certainly be for their benefit. And the other time, sometimes it can flag risk to the buyer, which is if they've been super aggressive, maybe there are other things going on in the company as well. So sometimes it can be a hot button when thinking about the M&A process generally, which is why we're all here today. I'm going to jump over or stick with Bob now. We talked about an NDA. What comes next? Is a letter of intent always come next? Do you jump to a purchase transaction? If you're dealing with a letter of intent, am I forced to close if I sign something? How do those things work together?
Typically, before you get to the letter of intent stage, you've got indications of interest from as many people as possible. And those people are involved in the process. I think we're going to talk about process a little bit further, but relative to an LOI, the LOI is really serve a couple purposes. One, you make sure that the buyer and seller are in alignment on key terms. You'd rather have that happen in a 5 to 10 page LOI than you would in a draft of 100-page purchase agreement. So, the key things: purchase price, payment terms, closing conditions, timeline, all of those things are typically spelled out. Secondly, it provides, the framework for any further negotiations that take place as part of the purchase agreement, which is important. As well, it provides sort of momentum and commitment on both sides to keep advancing the transactions. And in some cases, particularly for buyers, they need to have an LOI in place before they get sign off by either, their board of directors or their owners or whatever the case is. So it's really a way of avoiding wasted time and resources, setting valuation expectations, and then, facilitating that internal approval. There are some things that are typically binding in an LOI. For example, no shop, meaning exclusivity for the buyer for some period of time, which we talked about previously, maintaining confidentiality, allocating the expenses, if there are third-party expenses on this, whether it's for, could be for a Q of E report or something else, whether there are breakup or termination fees, where governing law is in case any disputes arise. And then, as you brought up, Rob, earlier, it's very important to have that employee non-solicitation in there under the LOI. But the things that usually aren't binding are purchase price, reps and warranties, closing conditions, indemnification, transaction structure. All those things are really up for grabs until the purchase agreement is signed. One of the issues with that, I was at a deal makers conference in Chicago. A lot of top deal makers were at this roundtable this morning. We were talking about buyers retrading deals, and historically, a buyer coming in right at the end of the deal and saying, "Hey, I saw some stuff I don't like. We're going to reduce the purchase price by 10%." That might have happened in 30%, 20, 30% of transactions. Today, that number is up at like 65, 70%. People are retrading transactions for all but the very best assets. But, the bottom line is that, look, the LOI is really important because while it's mostly non-buying, it does set the stage for closing the transaction and doing the purchase agreement.
So Bob, that was really interesting. I was listening particularly to see what direction it went in on retrading from 30%. And I don't know whether to be relieved or horrified that it's gone to 60%. But I will share two items briefly. Closing last year, there was an unresolved lawsuit that hung up the close. We had only one interested buyer. They retrade, if retrade is neutral, I can use that term. They said, "Hey, you know what? We have to allocate the X dollars to get this resolved, and so multiply that by whatever we're paying for you. That's the reduction." And okay, so we agreed to it. But I will say that in some sectors it's more pronounced, and in venture capital, where I've spent time, there's something called SHITS, which is what venture capitals sometimes some firms do, which is called show high interest then scram. And a company that is hung up negotiating with just one firm and needs the money, some firms will do that. Like, you know what? We don't have to close. You want to close? We see it a little differently now, and it's so this is from my venture capital days. We saw it. We didn't do it. It's not a good practice. Firms that do it a lot get to be known, but it is problematic.
Absolutely.
In your situation, Alan, a specific indemnity for that lawsuit wouldn't have worked. It must have been something very, primary to the business for it not to say, "Okay, we'll put back, $2 million and we'll have an additional escrow for this amount," but you argue over who controls it. It must have been very, important.
It was, Rob, and it was in a declining industry. And we only had one interested party that had, I won't say passed on it, but I had to work mightily. And so the seller, it was the last holding in the private equity fund that was closing. So highly motivated sellers, which we like highly motivated sellers. We didn't like that there was this issue that hung us up.
Okay. Before I get off the letter of intent, and for the group generally, how far do you drill down into deal points other than, price and mode of payment? Like, the general preference to me would be like customary indemnification and survival representations and warranties. I would be kind of, I think, the commercial way to go, but I've been in many deals where people want to put a pin in that. And I've had pages and pages of characterizing different types of reps and warranties and what their survival is, and baskets and caps. And like, as I explained to them, you can't really do that without diligence. And even if we put it in here, it's non-binding, and after diligence, it may be off the table. What's everyone's general experience as to how fine-tuned are deal points in LOIs?
So if I may continue, for our clients that sell, we put out about a page and a half of between 6 and 12. We say, here's for you to put in an indication of interest, which I'd love to hear if people view that as differently than an LOI. For you to participate further, we need an IOI, an indication of interest by this date, and it needs to have, these factors. What's the range of pricing? What's your capacity? What is your ability to close? So we lay out, ideally, when we get a lot, we're able to, compare them, and, the best offer that's the most complete, that is the most capable, is the one that we'll go forward with. But we do not, Rob, we do not get into anything like what you described. We don't ask for it. We don't want it. It's a waste. We don't ask for it and don't want it.
Okay. I'm going to ask Phil just to chime in a little bit about how binding an LOI is in respect to your ability to close. More like we've all sort of chimed in on the let's retrade the deal point. What's been your experience, Phil?
Well, I think it's been covered great. I think all three of y'all have covered what terms need to be in there, and it's going to really, the transaction is going to dictate the LOI. I mean, a really complex deal may have a more significant LOI, but my experience is LOIs are really only binding, and when I say binding as the key terms, and if there's a renegotiation, then again, when I look at a price, I don't set a price that's going to just be there. My whole deal is either on the buyer or the seller, I want to know a range. And it's going to be subject to due diligence. You can't say I'm going to sell the company for 10 million. You know in your mind as a seller what you're going to take, and you can give a range. So a lot of the LOIs I deal with, and again, this is more in financial institutions, but they'll have a range based on due diligence. And everything in the LOI is subject and conditioned to what occurs in due diligence. I mean, everybody can walk based on due diligence as a general proposition. So I don't worry as much about LOIs, except for the points y'all talked about: exclusivity, confidentiality, non-solicitation. I want those binding, and you can make those binding. But again, if you can set the price to begin with, then you don't need due diligence. And so it's got to be conditioned on that. There's the term commercially reasonable efforts, and we could talk about that for days, and different courts will say different things. I'd like to tell people, when you enter into a contract, there is the basic issue of good faith and fair dealing. And an LOI, in essence, is an agreement between the parties. So I think you've got that basic there of good faith and fair dealing. I don't like, and you mentioned this a minute ago, Rob, when people start using terms like, we'll agree that all the representations and warranties will be customary industry standards. Well, that really leads to more problems in my experience. That needs to be negotiated through the agreement, whether it's an acquisition or a merger agreement.
Great.
Bob, you want to jump in?
I would just say I agree with everything Phil said.
Okay, I get a harumph out of that guy. Phil, we started talking a little bit about the purchase agreement. We summarized some of its basic sections. When does it get drafted? Who holds the pen? How long does it take to get to execution? Typically, given that every deal is different and many have many more speed bumps than people initially anticipate.
Yeah, and we've kind of touched on this a little bit earlier when we're talking about exclusivity period and how everything's going with due diligence. First step is, most buyers are going to want to have the first draft on an acquisition agreement. If I'm representing the buyer, I want to draft the agreement. If I'm the seller, that's fine too, because the burden of drafting it initially for the buyer is better. And quite frankly, if I'm representing the seller, I'd rather review what they've given me as opposed to try to draft it for what they want. And so from that standpoint, I think it really falls to the buyer. And what I would tell you is my experience is that you want to have that acquisition agreement drafted and signed within about 30 days of concluding due diligence. And the preference is that you've circulated a draft while due diligence is going on, but you know you can't complete it until that's finished.
Do you suggest that the purchase agreement gets started early, or would you suggest to your buyer, which is, hey, we're all eager to close, but until we at least dip our toe in the pond of due diligence data rooms, no pen hits the paper or no fingertip hits the keyboard until a certain period of time?
And every buyer is different. If you've got an active buyer and they're out there doing acquisitions all the time, they may want to have an agreement ready to go and tweak it as you finish due diligence. If you've got a first-time buyer that may be cost conscious, they're probably going to hold you back until they get further into due diligence and then expect you to perform in a shorter period of time to get that draft out to the seller. So I think, again, it depends on who the buyer is and the complexity of the situation. I've done it both ways.
Okay, that raises another point, which is I see more and more of, at least on buy side, certainly on the financial buyer side, with the LOI, is asking the seller for a deposit towards expenses. And then from the sell side, you got to be careful that that deposit doesn't get eaten up, because if the deal breaks, the typical provision of one of those is to get the unused deposit back. So you got to be careful that, say, for example, your buyer isn't trying to top off its counsel on a blown deal, having them race off and draft the document for a deal that's probably not likely to happen. So has anyone seen, and I think I've asked this in prior episodes of this, an expense deposit up front from the sell side being on the table or requested? I see it a little bit more than I used to. It's not commonplace, but it's certainly not unusual anymore.
To run into one of those, Rob. And I think I would advise my client most of the time to say, nah, non-starter.
You're a tough man.
Well, and Bob, the other thing I'd say is, I mean, if I've got a buyer that's telling me, if I represent the seller and they're telling me I want a deposit for expenses, well, my first question is, well, what if you walk away and I've incurred all these other expenses in due diligence? I will tell you, if I'm representing the seller, I turn that around. If I've got to pay you because I walk away, I want you to pay me if you walk away. And that usually ends that conversation.
I had it happen once, actually over the summer. I think it actually got in the way of the deal and created hard feelings. And I think there was a 50-50 chance that something could have happened. It was a financing and went sideways, and then it just went away. So I think the answer is no, thank you.
Financing, I'm a little more, I see financing sources looking for deposits frequently, if not always. But just on an M&A transaction, everybody's got their own expenses until there's a deal in place.
All right, a couple more topics to talk about before we bid our watchers and listeners adieu. I'm going to go back with Phil. We talked about LOIs, we talked about NDAs, we talked about the main purchase agreement. What are some of the other documents? What are the ancillaries that are typically pop up, and when do they join the party?
Well, and again, depending on the structure of the transaction, if it's a merger, you probably won't have as many ancillary documents. If it's a P&A, a purchase and assumption, you're going to have more documents. But some of the ones, and I'll kind of list them out. I mean, if it's a purchase and assumption, you're going to have a bill of sale. If it's a merger, you're going to have some stock transfer documents, and you may have an escrow agreement on how you're going to fund the sellers. You'll have corporate resolutions. You'll have third-party consents. if it's a regulated industry, you'll certainly have the regulatory approvals that'll be in there. Some of the other things, and this is really the big one, and people forget about this. When you negotiate the agreement, if it's got a disclosure schedule, and most do, the amount of time that is spent really putting that disclosure schedule together to have an accurate document and exhibit to your merger agreement can be pretty extensive. So that's one. Like I said, the assignment and assumptions, and that could be for if it's in a P&A, that could be for different pieces of assets. I mean, if you've got intellectual property, you may want to have a different agreement. If you've got real estate, how you're going to get that. Some of the other things would be if you're going to have consulting agreement with the former owner, the seller. You could have escrow agreements that we've talked about, non-solicitation agreements. It really gets back to the structure of the transaction. And I hate to even mention this one because we all try to stay away from this. If you've got seller owner financing, then you've got a whole other set of lending documents that you have to deal with. Notes, security agreements, pledges, deeds of trust, so on and so forth. So it can be very extensive. And I know I haven't covered anything, but if I've missed any big one, please, y'all jump right in.
That's pretty comprehensive, and it supports what I often tell some of the smaller principals in smaller deals, which is there's really no such thing as a small deal.
Yeah.
It's so hard to streamline a deal where you have, for example, employment agreements, or you're going to give a seller note and there's going to be security. Let's talk briefly before I shut us down for the day. Management team employment agreements. Exhibit to the purchase agreement, or that they sign at closing, or if you're wearing the buyer, would you prefer to have them signed in advance, but with an effective date as at the closing? When's your leverage to get your terms, and when do you want to be careful here? And anyone can chime in.
Well, it's buyer driven, and depending on the assuredness of close, I'm going to assume for this conversation, it is people who have been involved in the transaction so that there's not this huge disconnect on confidentiality. So if the people who have been, let's say it's 3-4 executives, they've been involved in the close, they know about it, they've been participating, it's what the buyer wants at that time of close, from what I've seen.
Yep.
My experience, Robert, is if you have key employees identified, you want to get that employment agreement to them before you're, right at the 11th hour of signing that asset purchase agreement. Because if somebody doesn't come along and they're a key employee, that changes the complexion of the deal pretty dramatically.
Yeah, and
From the
Robert,
buy side,
go ahead.
Phil.
You go.
From the buy side, I want it signed today early with the effectiveness upon closing. The deal blows apart, there's no agreement. I don't want to be close to closing and having to negotiate with the key employee.
I would agree with what all of y'all have said. I mean, I've been involved in transactions where employment agreements show up 2 days before closing and had key people say, not signing it. And so I really think important points like that, and this is the other thing we're not talking about really here, but any kind of employee benefits that are going over, I think that's a discussion that has to be had early on. You need to try to keep the people that are going to be with the surviving entity. And if you don't let them know what the benefits are, and I'm just talking about health insurance, you may lose them the day of closing too.
All right, well, that about wraps us up. I'm sure Alan wants to turn around and get on his little sailboat and sail into the sunset back there. Thanks again to our sponsor, Max Asset. You could learn more about Max Asset on slide 3 of the deck, and of course to our wonderful panel. You can join me on November 4 for episode 4 of the 2025 M&A Bootcamp. We'll be talking about post-closing integration and buyer and seller disputes. Until then, stay well, stay safe, and thanks again, everybody. It was big fun.
Thank you all.
Great job. Thank you.